We're live.
Good morning. The meeting will now come to order. Welcome to the June 23rd, 2020 meeting of the Durham Board of Adjustment. My name is Jacob Rogers. I'm the chair of the board. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform as permitted by Session Law 2020-3. This is the second remote meeting of the Durham Board of Adjustment and the first remote BOA meeting with quasi-judicial hearings. I would ask for your patience today as we proceed. There may be slight delays as we transition between speakers as well. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance. The board typically conducts evidentiary hearings on requests for variances, special use permits, among other requests. Today's meeting will proceed much like an in-person meeting of the Board of Adjustment. On the screen, you will see the members of the BOA. Additionally, planning staff and representatives from the city and county's attorney's offices are attending in the remote meeting. Applicants were required to register in advance and are also attending the remote meeting. When a case is called for its hearing, applicants and witnesses will be promoted within the remote platform so their video can be seen. The chair will swear in applicants and witnesses at the beginning of each case. Staff will present each case and applicants will then provide their evidence. Control of the presentation and screen sharing will remain with planning staff. Today's meeting is being broadcast live on the city's YouTube site, and a link to this broadcast is on the website for the Board of Adjustment. Before we begin the evidentiary hearings on today's agenda, I would like to provide some important information about steps taken to ensure that each party's due process rights are protected as we proceed in this remote platform. Each applicant on today's agenda was notified that this meeting would be conducted using a remote electronic platform. During registration, every applicant on today's agenda consented to the board conducting the evidentiary hearing using this remote platform. We will also confirm today at the start of each evidentiary hearing that the participants in the evidentiary hearing consent to the matter proceeding in this remote platform. If there is any objection to a matter proceeding in this remote platform, the case will be continued. Notice of today's meeting was provided by publishing notice in the newspaper, mailed to property owners within 600 feet of the subject properties, posting a sign at the property, and posting on the city's website. The newspaper, website, and mailed notices for today's meeting contained information how the public can access the remote meeting as the meeting occurs. These notices also contained information about the registration requirement for the meeting, along with information about how to register. All individuals participating in today's evidentiary hearings were also required to submit a copy of any presentation, document, exhibit, or other material that they wish to submit at the evidentiary hearing prior to today's meeting. All materials that the city received from the participants in today's cases, as well as a copy of city staff's presentations and documents, were posted on the Board of Adjustment website as part of the agenda. No new documents will be submitted during today's meeting. No case is proceeding today in which the city has been contacted by an individual with an objection to the case or an objection to the matter being heard in this remote meeting platform. All decisions of this board are subject to appeal to the Durham Superior Court. Anyone in audience other than the applicant who wishes to receive a copy of the formal order issued by this board on a particular case must submit a written request for a copy of the order. And at this time, I would like the clerk to call the roll, please.
Jacob Rogers.
Here.
Chad Meadows.
Here.
Chris Burnham.
Here.
Frederick Davis. Regina DeLacy.
Here.
Ian Kipp.
Here.
Michael Retchless.
Here.
Micah Jeter.
Here.
Jessica Major.
Here.
Tisha Wymore.
Here.
All right. I've also got a couple of other announcements. I want to just housekeeping items, if you will. For the board members, let's refrain from using the chat box. Also, use the raise your hand feature within the, I think it's the chat box or the participant panel. You can do that. And please identify yourself prior to or before you start speaking. And then I'll be giving the oath. I mentioned this earlier, but I'm going to say it again. I'll be giving the oath to everyone for a particular case on the onset of each case. So the next thing we have on, I guess, are there any adjustments to the agenda? None. Okay.
Staff, there is an adjustment to the agenda. Eliza Monroe speaking with the Planning Department. Case number B20000006. The applicant requested to withdraw this case, so it will not be heard today.
Thank you. All righty. Well, let's, has everyone had the opportunity to look over the minutes of our last meeting? And we would entertain a motion for approval.
Meadows move approval of the minutes from May 26th.
Kip second.
All in favor, say aye.
Aye.
Any objections? Okay.
Susan, please call that by roll.
Oh, we didn't do that.
Jacob Rogers,
Yes.
Chad Meadows,
Yes.
Chris Burnham,
Yes.
Frederick Davis, I'm sorry, he's out. Regina DeLacy,
Yes.
Ian Kipp,
Yes.
Michael Retchless,
Yes.
motion carries 6-0.
Should be at least 7.
One more is,
The designate Tisha Wymore.
yes.
Right. All right.
Motion carries 7-0.
Thank you. Madam Clerk, would you like to call the first case?
Case B19-00032 is a request for minor special use permit to allow a parking reduction greater than 20%. The subject site is located at 1052 Andrew Chapel Road, is zoned planned development residential and in the suburban tier. And this case has been advertised for the required period of time, and property owners within 600 feet have been notified. Notarized affidavits verifying the sign postings and letter mailings are on file.
Thank you. Planning staff like to take it over.
Yes, taking it over now, trying to share my screen. Okay, sorry about the wait, everybody. Case Eliza Monroe representing the Planning Department here. Case B19-00032 is a minor special use permit request to permit a parking reduction greater than 20%. The applicant is Morningstar Law Group. The subject site is located at 1017 Andrews Chapel Road in Durham. The case area is highlighted in red. The site is within the suburban tier, zoned planned development residential or PDR, located within the Falls of Neuse Jordan Lake Protected Area, Watershed Protection Overlay District, and the Major Transportation Corridor I-40 Overlay District. It is also within the city's jurisdiction and is on the screen there in red. The site area is currently vacant. The applicant is proposing to have a residential development there, primarily consisting of apartment units. Per Unified Development Ordinance, Section 10.3.1B.10, except for within the compact neighborhood tier, reductions of more than 20% of required motor vehicle parking shall require the approval of a minor special use permit. The site is currently vacant, as I mentioned before. A site plan, which was in your packet as attachment 4, is currently under review and proposes 298 apartment units, a clubhouse, and pool. The uses were approved with the development plan in 2012, which is attachment 5 in your packet. The Unified Development Ordinance would require the site to have 658 spaces. That would be 2 spaces per the 298 units, plus a one space per 100 square feet of the clubhouse. The applicant is requesting a reduction from those 658 spaces for a total of 527 motor vehicle spaces. UDO section 3.9.8A and B establishes 4 findings and 13 review factors that the applicant must meet in order for the board to grant a use permit. These findings and review factors are identified in the staff report, and the applicant's responses to these findings and review factors are identified within the application, both of which are within your packet, and staff will be available for any questions as needed during the hearing process.
Thank you, Eliza. Any questions for Eliza before we proceed?
I believe Meadows has raised his hand.
I did. Thank you. This is Chad Meadows. Eliza, I apologize for not getting this question to you beforehand. In looking at the site plan, I noticed that the vast majority of this site is inside Wake County. Is that an error, or will Wake County, how does the jurisdictional issue work here with respect to the portion of the property that's inside Wake County?
The portion that we're discussing today is just the 1052 Andrews Chapel Road. I am not familiar with the Wake County process and how we will reach out to them. And if that is necessary, I'll have to reflect upon legal staff to maybe provide some insight there, or any other staff members. But the portion that we're only able to approve the MSCP for is going to be the 1052 Andrews Chapel Road. The other portion, I'm going to scroll a little bit here on the screen so that I can show the other members of the board what Chad is referring to. The red highlighted area is a part of the site, but so is the dark blue area directly underneath it. That part is within Wake County and therefore is not part of the red highlighted area.
Any other questions for staff for Eliza? All right. Would the applicant, I would say come forward usually, but I also want to, before we start, before the applicant starts, I want to administer the oath to everyone who will be speaking in this, for this case. So who is the applicant? Is Morningstar?
Morningstar Law Group, and I believe they do have some additional people on their team today that will also be needing to take that oath.
Okay. Neil, I think I saw you on the roster. Are you there?
Patrick, right? Neil, Patrick.
I can hear some whispers, but I'm not sure if that's us or not.
You've got Mike, Tonti, and Chad Boyette. We're like, I can wave.
All righty. Okay, well, this is going to be for all the speakers for this this case. Do you solemnly swear or affirm that that your testimony and evidence shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you. All right, well, you may proceed if you'd like.
Chair, this
Yes.
is Krista Kugro with the City Attorney's Office. We also need to get verbal consent of the participants to the remote meeting format.
I wrote that on the agenda here. I forgot to do that. So does the applicant consent to this remote meeting?
Yes.
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 Thank you. Well, you please continue or start.
And
Thank you. Oh, go ahead, Eliza.
Just going to reiterate earlier for Chad and Jarvis, I don't know if they were in earlier, but for control of the screen, that will be staff. So if you have any specific pieces of information you want to pull up from the attachment submitted, please just direct me and I'll be sure to pull those up.
Chair, this is Krista Kugro, City Attorney's Office. I believe Mr. Ghosh was not on the call when you administered the oath, and I'm not sure about the consent. So if we could just make sure that that was done. Thank you.
All right. Mr. Ghosh, do you solemnly swear or affirm that your testimony and evidence shall be the truth, the whole truth, and nothing but the truth?
I do.
And do you consent to this remote meeting platform?
Yes, I do.
All right. Thank you. You can start.
Thank you, Chair Rogers and members of the Board of Adjustment. I am Neil Ghosh, an attorney at the Morningstar Law Group at 112 West Main Street in Durham. I am representing the owners of the property located at 1052 Andrews Chapel Road, and we will present evidence in support of the application for a parking reduction. The permit relates only to the parking reduction, not the proposed use itself, which is generally permitted at this location. So the evidence will be focused upon the impact of the reduction and not the more general aspects of the use. As staff mentioned, we are requesting a parking reduction of around 20%. We believe the requested permit is warranted for the reasons which will be shown by the evidence that we will present to you today. And at this time, I would ask that all materials referred to or used by the witnesses, including the staff report and all of its exhibits, be entered into the record, and that judicial notice be taken with regard to the contents of the UDO, the comprehensive plan, and other adopted plans of the city and county of Durham.
So noted. Thank you.
In addition to those, we have some exhibits which we submitted to staff earlier. They are the reports of our expert witnesses. One is from Mr. Jarvis Martin, who we are tendering as an expert witness in the field of real estate appraisal. He is a certified real estate appraiser with Stewart Martin McCoy. And the other report is a parking study, which was done by Mr. Earl Llewellyn at Kimley Horn and Associates, and he is a traffic engineer. I just wanted to make sure that those things would be entered into evidence and that those two witnesses would be accepted as expert witnesses capable of giving opinion testimony consistent with the requirement laid out in General Statute 160A 393K.
All right. You can proceed. Yes.
Okay. So for me, the easiest way to describe the location is that it is behind the Harris Teeter at the corner of TW Alexander and Highway 70. The property is very much part of Briar Creek. There will be direct vehicular access to the Harris Teeter Shopping Center from the site. The development plan for this area included this use. It was approved in 2012, which I believe Eliza mentioned earlier. We're excited to see this section of the project finally being built out, and we're requesting your approval of a minor special use permit for a parking reduction for that purpose. Our first witness will be Mr. Earl Llewellyn.
Good morning, everyone. I am Earl Llewellyn, traffic engineer with Kimley Horn and Associates at 300 Moore Street in Durham. I routinely conduct traffic impact and park analyses like these, as well as overseeing roadway designs, traffic signal designs, and the like. I graduated from NC State with a BS in civil engineering. I'm a registered professional engineer in North Carolina and have worked in the traffic engineering field for over 30 years. As Neil said, I conducted the parking study for the project, which uses current industry standards, parking methodologies, et cetera. And that study has been entered into the record by Neil. My report assumes the development will consist of 298 mid-rise apartment units. That's basically between 3 and 10 stories, as well as a clubhouse of 7,268 square feet. Since completion of the study, the clubhouse has reduced to 6,218 square feet. So based on that site plan, the UDO would require 658 parking spaces. The applicant is providing 527, which is approximately a 20% reduction. Based on information provided by the applicant, my report examines parking demand using 2 independent variables. Those are one, the number of units, and number two, the total number of bedrooms proposed.
Mr. Llewellyn, I apologize. Would you mind turning your camera on, please?
Given my setup, that's a little difficult, but I will try if you bear with me.
Thank you. Thank you very much.
Okay, sorry about that. So the clubhouse and amenity area are not variables that ITE relate to maximum parking demand. If you think about it, the maximum parking demand for apartments occurs overnight when the amenity areas are not in use. So while that data is very likely included, amenity areas such as clubhouses and pools are included in a lot of the ITE data, those really aren't independent variables used to calculate the maximum parking demand. Using those ITE rates, the parking generation manual specifically, the following rates are expected for this type of land use in this location. It's 1.42 spaces per unit or 0.84 spaces per bedroom. The requested parking reduction will provide a rate of 1.77 spaces per unit, which is, again, about 25% higher than the ITE rates, or 1.18 parking space per bedroom, which is 40% higher than the ITE rates. Therefore, it's my professional opinion that the proposed parking reduction will adequately accommodate the expected parking demand. And I'm happy to address any questions you might have.
Any questions for Mr. Llewellyn? I can't see any raised hands, so if there are.
Regina has raised her hand.
Mr. Lacy.
Yes. In practice, you'll have what happens about visitor spaces? I mean, if you're want to have 1.7 spaces per unit, what happens when somebody has a visitor? Will there be sufficient? You said mostly overnight. I'm assuming that some people will have overnight visitors, and where are they going to park?
The overnight visitors are included in these studies. So overnight visitors are included in this 1.42 parking demand rate.
DeLacy, can you speak to that, how it's worked in the past, in your professional opinion, with regard to parking pressure?
With regard to parking, what? I couldn't.
I just call it parking pressure. Anybody who's been a day hop in a college knows that at certain times of day, there's just no place to park. And day being the highest point of what I had referred to as parking pressure.
Yeah, we refer to it as parking demand. And what the ITE data is a collection of studies across the United States that look at apartment complexes like this in similar areas, which in this case is suburban, urban, that does not have access to light rail. And based on all of these studies, it basically goes out and looks at the parking demand of each facility and determines when the maximum rates of those occur for a variety of uses, not just apartments, but across the land development spectrum or land use spectrum. And those highest, maximum demands are what they record. So they're recording the data of parking being used at its peak. Those are the rates that are reported by ITE. Does that answer your question?
Lacey, yes, thank you.
Any other questions for Mr. Llewellyn? Thank you, sir.
Thank you all.
Thank you, Earl, and our next witness will be Mr. Jarvis Martin.
Good morning, Mr. Rogers and members of the Board of Adjustment. My name is Jarvis Martin. I'm a state certified general appraiser. I have 2 degrees from North Carolina Central University in business, and I've been in the real estate business here in Durham for over 40 years. I'll be glad to answer any other questions that you may have about my qualifications or resume. My firm was requested by the applicant to look at this property to see if we could gauge if there would be any adverse impact on this parking reduction of the surrounding or nearby properties. Since this excuse me, development would be adjacent to an existing shopping center, what we did was to look at 3 apartment complexes that had been approved with reduced parking that was in close proximity to commercial facilities, as well as look at shopping center facilities that have not been impacted by apartments with reduced parking requirements. With commercial property, the best way to gauge value is by looking at the rental rates and vacancy. In the 3 shopping centers that we looked at that were not impacted by close by apartments with reduced parking, we determined that the rental rate for their space ranged from $25 up to $36.50 per square foot. When we looked at centers that were in close proximity to the 3 developments that did have some reduction in parking, the rental rates in those centers also range from $25 up to $32 per square foot. And the vacancy rates in all these centers at the time of the study was in excess of 95%, which is considered, full capacity in the market. It is generally known, again, that if you're going to have reduced parking in an apartment complex and having it in close proximity to places where people could walk and shop, that would be an asset for those surrounding properties. So based upon the rental rates and the fact that we could gauge no factual impact, it is our opinion that the reduction in these parking spaces will not have any adverse impact on adjacent or nearby properties, and that my study concludes and backs up what is said in the traffic study, and therefore we recommend approval of the minor special use permit. And I'm available for any questions.
Any questions for Mr. Martin?
I have a question.
Mr. Kip.
What is the relevance of the price per square foot for the commercial space in this exercise?
Well, the relevance would be that I looked at the price per square foot at the shopping center there in Briar Creek and compared it to the market since this department is not there, and this is within the range of the $25 to $32 a square foot. And then looking at the square foot rate of commercial spaces that was in close proximity to units, to developments that had a reduction in parking for the development, and those that were not impacted by such further away, to see the correlation if there was any reduction in demand for those units that was close to the complexes that had the reduction in parking. And what this study says is that they're all within the same range and their vacancy rates were pretty much the same. So therefore, I see no adverse impact from this development being constructed with reduced parking on the commercial center there at Briar Creek or any other surrounding properties.
Thanks.
Any other questions for Mr. Martin, Jarvis Martin?
If it's okay, could I ask a direct question to my own witness, Mr. Martin?
Sure.
Mr. Martin, just to clarify, I just want to make sure, in your study, the commercial rental rate is used as a proxy to determine the value and the impact to value that an apartment complex might have based on a parking reduction. Is that right?
That is correct.
That was my question. I'll leave it back to you, Chair Rogers.
Thank you. Any other question? Looks like Regina Do you have a question? You're muted.
My question, the $25 to $32 a square foot, is that per year? Or are you referring to a different value?
That is the rental rate that the tenants are paying to the landlord to rent these spaces. And again, that rate varies depending upon the size of the space. Typically, larger spaces justify a smaller rent, and smaller spaces typically on the high end. So that is the rental rate that they are getting for those spaces within those centers.
My question, DeLacy, my question is the rental rate per month or per year?
That is an annual square foot rental rate that's calculated per square foot and then paid on a monthly basis.
Thank you.
Any other questions?
Meadows has his hand raised, Chair Rogers.
Mr. Meadows?
Thank you, sir. I have a question for Mr. Ghosh. I assume that the balance of this property is in Raleigh. Do you have approval from Raleigh? Was any special use permit or other waiver or reduction necessary from the city for the parking that you're proposing? And if so, have they approved that?
So the balance of this property actually is in Durham. It's also in Wake County.
Okay.
Which is odd, but ultimately the planning jurisdiction in this case falls to the city of Durham. So we are not required to get any additional approval from the city of Raleigh.
Thank you.
All right, any other questions for this particular witness, Mr. Martin? Mr. Ghosh, you want to free to continue?
Yes, thank you. This is Neil Ghosh for the record again, speaking on behalf of the applicant. And you've just heard expert testimony from Mr. Earl Llewellyn and Mr. Jarvis Martin about the parking reduction. There are other factors which the board must consider before granting a special use permit, but this particular permit does not implicate many of those factors. As outlined in the staff report, the parking reduction does not have any bearing upon circulation, service entrances, lighting, signs, utilities, open spaces, environmental protection, or screening, buffering, and landscaping. As Mr. Llewellyn explained, the proposed reduction is compatible and in harmony with the approved development plan rezoning for the area. The parking reduction will provide adequate parking for the expected demand and will not adversely affect public health and safety. Finally, as Mr. Martin explained, the proposed reduction will not substantially be injurious to the value of properties in the general vicinity. All of the competent substantial material evidence in the record shows that the applicant has met all of the requirements of the UDO for your approval of the requested minor special use permit for the parking reduction, and therefore we respectfully request your approval. We'll be glad to address any questions that you may have. Thank you.
Are there any questions for the applicant?
Staff does not have a question, but just wanted to, for the record, if all the applicants could potentially just speak their name. Usually we ask people to introduce themselves before they speak, just one more time so we have an adequate record.
Jarvis Martin.
Earl Llewellyn with Kimley Horn.
It's Mike Tonti and Chad Boyette with applicant. And we just wanted to clarify, which I think Niall clarified earlier, the site plan for this apartment community is within the Durham jurisdiction, even though part of the property is in Durham County and part of the property is in Wake County.
And this is Neil Ghosh, the attorney for the applicant.
Thanks y'all so much for chiming in. Just want to make sure we get this right the first time around.
Any questions for the applicant or any witness? Just for the sake, just in case we didn't miss it or we missed this, anybody on the call opposed to this? Who wishes to? All righty. We will close the public hearing. Any discussion among the board members on this particular case? All right, well, would staff like to give a recommendation?
Staff recommends the approval of case B19000032, such that the improvements shall be substantially consistent with the site plan, case D19000031, and all information submitted to the board as a part of the application.
All right, does anyone want to make a motion?
Meadows, I'll make a motion. I hereby make a motion that application number B19000032, an application for a minor special use permit on property located at 1052 Andrews Chapel Road, has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted, subject to the following conditions. The improvements shall be substantially consistent with the site plan, case D19000031, and all information submitted to the board as part of the application.
We have a motion. Is there a second?
Lacy, second.
All right, Madam Clerk, will you call the board members?
Ms. Burnham,
Yes.
Ms. DeLacy,
Yes.
Mr. Kipp, I believe Mr. Kipp's muted.
I did say yes, I'm sorry. It was muted. Thank you.
Thank you. Mr. Meadows,
Yes.
Mr. Rogers,
Yes.
Mr. Retchless,
Yes.
and Ms. Wymore.
Yes.
Motion carries 7-0.
By a vote of 7-0, your minor special use permit has been granted. You'll receive a formal order from planning shortly. Thank you for coming before the Board of Adjustment.
Thank you. Have a good day.
You too. Madam Clerk, would you like to call the next case?
Case B20000001, a request for a variance from the sidewalk requirements. The subject site is located at 510 East Pettigrew Street, is zoned downtown design core, and is in the downtown tier. And this case has been advertised for the required period of time, and property owners within 600 feet have been notified. Affidavits verifying the sign postings and letter mailings are on file.
All right, thank you. Would the staff like to take over? Eliza, you have this one?
Yes, I do. And I am beginning to share my screen now. Good morning, everybody. Eliza Monroe once again with the Planning Department. Planning staff requests that the staff report and all materials submitted at the public hearing be made part of the public record with any necessary corrections as noted.
So noted.
Thank you. Case B20000001 is a request for a variance from the sidewalk requirements of the Downtown Design Core Zoning District. The applicant is Klein Design Associates. The subject site is located at 510 East Pettigrew Street. The case area is highlighted on the screen in red. This site, as I mentioned before, is in the downtown tier, zoned DDC, and is within the city of Durham's jurisdiction. The site is currently vacant. Per UDO section 16.4.2A.1, within this DDC zoning district, sidewalks shall be provided from the building face to the back of curb. For this site and the approved location of the building, that will result in the sidewalk widths within the range of 27 to 34 feet wide along the wooden exchange lane and a roughly 40-foot sidewalk along East Pettigrew Street. The site is currently vacant, as I mentioned before, but a site plan was approved in October of 2019, case D1900079, to permit the construction of the apartments here. The site, the applicant is requesting a variance from section 16.4.2A.1 of the UDO to instead permit a 12-feet sidewalk around the site at the back of curb to contribute to a visual environment downtown. Additional landscaping would be provided between the building and the sidewalk. In UDO section 3.14.8 establishes 4 findings that the applicant must make in order for the board to grant a variance. These findings require approval and are identified in the staff report, and the applicant's responses to the findings are identified in the application, which are both within the packet that you all received. Staff will be available for any questions as needed during the hearing process. On the screen here, we do have a couple of different maps, which were also a part of the packet, and I'll be flipping through them as I was doing before with the previous case. So the first screen here is the context map. This is what is required by the current Unified Development Ordinance. So as I mentioned before, the 27-foot sidewalk along the wooden exchange lane and the 34-foot sidewalk here, and then a roughly 40-foot sidewalk on the East Pettigrew side of the site. The very last slide is kind of a concept plan in which the applicant is proposing to have instead, which would require a variance to allow for a 12-foot sidewalk. So that is all I have at the moment, if there's no questions from the board.
Any questions for staff before we continue? All right, thank you, Eliza. Would of course, I can't see how many people we've got, but it looks like Mr. Buff. Is there anyone else to speak for this or any other witnesses?
It might just be Mr. Buff.
Okay. All right. We need to administer the oath for you. Do you solemnly swear or affirm that your testimony and evidence shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. And do you consent to using this remote platform?
I do.
Thank you. Please tell us about this project.
All right. I'm Elliot Buff. I'm representing the client. I work with Kalan Design in Raleigh. We're an landscape architecture, interior design firm. And I'm a landscape architect with 13 years of registered experience. And I've been with Kalan Design for 16 years. And this is 510 East Pettigrew Apartments. And I appreciate Eliza for kind of going over the initial packet that the exhibits we've already put together. I think the context map showing just the existing conditions and the 2 maps showing what is the code condition and then what is our proposed condition. We're requesting a variance for sections of the project that are fronting 2 streets with unique conditions. We have Wooden Exchange Lane and we have East Pettigrew Street. Due to the orientation of Wooden Exchange Lane, it's an existing street with a curvilinear design, and East Pettigrew Street, due to several different factors of an existing right-of-way reservation and a right-of-way dedication, results in a very large frontage along East Pettigrew Street. And the curvilinear nature of Wooden Exchange Lane results in a very open area between the curved street and the building face. The building was approved with the site plan, so we currently have an approved condition meeting the ordinance requirement of having sidewalk running from back of curb to the building face, and that showed in the code condition, and that has been approved. And we're requesting the variance to allow for additional landscaping and a 12-foot sidewalk width. Within the packet, we've already outlined the cases for all hardship, and I think the exhibits help clarify the request that we're trying to make here.
Do we have any questions for Mr. Buff, the applicant?
Meadows has his hand raised. Chair Rogers.
Mr. Meadows.
Thank you, sir. Mr. Buff,
Yes.
I noted there's two differing lines. There's a right-of-way dedication and a right-of-way reservation. Will all the land area between the East Pettigrew Street paving and the right-of-way reservation, is that going to go to the city, or can you help me understand the distinction between dedication and reservation?
It has to do with the right-of-way reservation. Let me get oriented. I believe the right-of-way dedication is just for future roadway improvements. The right-of-way reservation is reserved as a part of any future Go Triangle Master Plan documents. If I think there's 2 levels of improvements that are proposed on East Pettigrew Street, and the dedication is for the first level of improvements, and ultimately the right-of-way reservation is for the second level of improvements.
So if Go Triangle follows through with plans that are adopted, then we would see the Pettigrew Street right-of-way grow to the red line marked right-of-way reservation.
That's right, and the project's been approved, designed and approved with that ultimate reservation as the final design.
One more question, sir. Where is the front entrance of the building?
The front entrance is really along East Pettigrew Street. Liza, if you could flip to the probably the second exhibit of the proposed condition, or even the code condition, that's fine as well. There is the corner, really the corner of Wooden Exchange Lane and East Pettigrew is the front corner of the building. And there's a main entry, sort of where you see that rectangular planter there near the front corner of the building. That's really the front door.
Okay. Thank you.
Any other questions for the applicant? Mr. Buff, do you would you like all of your written and oral testimony to be part of the record?
Is that, I assume normally, yes, I would like that.
In exhibits, and it's just something we have to put on the record. I appreciate that. Any other questions for the applicant? All right. Eliza, you went, there you go.
Hi, this is Rexless. Mr. Buff, the trees, are there going to be any planters around these trees or kind of obstructions? Is the sidewalk going to be flush so people aren't tripping over these areas?
The sidewalk is a continuous flush sidewalk, and the tree plantings are flush tree grate pavers with bricks on top too. So you have a continuous flush surface there at the sidewalk, and that's a Durham approved standard streetscape.
Great, thank you.
I've got a question. I'm looking at what we've got on the screen now. This light green color between this, it looks like the edge of the building, the dark green, and then the trees. What is that light green? Is that just, that would be vegetation or?
It is. Conceptually, we're showing shrubs at the base of the building and then lawn between the shrubs and the sidewalk.
Okay.
Any other department? Sorry, Chair Rogers, just wanted to chime in really quickly in relation to Mr. Rutch's comment. If approved by the board, this change would have to go through a site plan amendment since it is a previously approved site plan. And at that time, all departments would ensure that what is being proposed will be built up to the standards of the UDO and any other codes.
Thank you, Eliza. All right, any other questions before we close the public hearing? All righty, we'll now close the public. Well, first of all, just in case, is there anybody on the line who is against this application? Hearing none, We'll close it. Any discussion among the board members?
Mr. Chair, this is Meadows. I have a question about, I assume that the city will be maintaining the area that's inside the dedicated right-of-way, or there's some sort of agreement between the city and the applicant about maintenance of the vegetation in the right-of-way. Wasn't sure about that.
Good question. Eliza, do you have an answer, or does the applicant have a?
I do not have an answer at this time because this is not something that has been formally submitted to the city of Durham in terms of this request to change over. For the right-of-way maintenance, I do believe that is within our general services department, and I'm looking at virtually Jessica and Bo to correct me if I'm wrong within that range. I'm not aware at this time of any partnerships or agreements between us and Go Triangle for the area that is the right-of-way reservation.
This is Jessica Dockery, Planning Department. The city does maintain the right-of-way.
Thank you, Jessica. Any other discussion? I kind of like the area with less impervious surfaces, such as this. Something a little more creative, I would think. It looks to me. So those are my thoughts. All right. Was anyone having a motion?
Oops.
I believe there was a raised hand by DeLacy.
Oh, I'm sorry, Mr. Lacey. You may be on mute. You are on mute.
Hang on. Okay. I agree with you about my joy at less, with your joy at less impervious surface, but I was thinking about how crowded the sidewalks are when it comes down the street toward the ballpark, and how people just and the DPAC, and how people just flood that whole sidewalk. And I was just musing as to whether they would continue to spill out on sidewalks further away than that, or are people no longer interested in walking that far? That was my only musing. It's not an objection, it's just a thought.
Well, I was wondering, and I don't think I saw this, the number of units in this. Eliza, do you happen to know how many units are in this?
I can pull up the exact site plan. Elliot, I might default to you here. The number of units wasn't a part of the variance request, so that information wasn't required. But I can pull up very quickly. So let me go back on mute. And Elliot, if you have the number of units for the original site plan, I don't think you're muted.
I wish I did. I don't have that number in front of me.
It's okay.
And for me, all the number of units blur together anyway. But if Eliza, if you do pull that up, just so we can formally acknowledge that. But to acknowledge the sidewalk comment, I think our goal was to still provide a 12-foot sidewalk, which is consistent with Durham standards and is consistent with a very large, clear pedestrian pathway of 12-foot width. And that's 12 foot of paving with the tree planters along the streetscape edge, along the back of the curb. Those are still hardscaped tree planters with brick paving above. So you have a clear pedestrian route throughout that entire streetscape area.
All right. Any other comments, discussion among the board? All right. We're not getting a staff recommendation for this variance. Is there a motion?
I'll do it. This is
Hey,
Meadows.
Roger.
Hold on.
This is Jessica Dockery. I believe you're holding for that site plan number. Eliza was still trying to find that.
Yes, and unfortunately, the SharePoint file, I'm not able to locate the SharePoint file for it, so I do apologize. I'm not able to pull up that exact number.
Okay, it's again, like you said, it's not part of the, this variance, but I just want just a simple question, but I appreciate you looking. Mr. Meadows, I think you were.
Thank you. I hereby make a motion that application number B2 0000001, an application for a request for a variance from the sidewalk requirements on property located at 510 East Pettigrew Street, has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted, subject to the following conditions. The improvements shall be substantially consistent with the plans and all information submitted to the board as part of the application.
We have a motion. Is there a second?
Retchless second.
Thank you. Madam Clerk, will you call the board?
Ms. DeLacy,
Yes.
Mr. Kipp,
Yes.
Ms. Burnham,
Yes.
Mr. Meadows,
Yes.
Mr. Rogers,
Yes.
Mr. Retchless,
Yes.
Ms. Wymore.
Yes.
Motion carries 7-0.
By a vote of 7-0, your variance has been approved. You'll get an order from the planning department shortly. And Mr. Buff, thank you for coming.
Great, thank you. Thank you for your time, everyone.
Have a good day. Madam Clerk, would you like to call the next case?
Sure. Case B2 0000003. A request for a variance from the required street and side yard setbacks in order to construct an addition on a single family dwelling. The subject site is located at 105 Farintosh Place, is zoned residential rural in the Eno River Protected Watershed Protection Overlay and in the suburban tier. And this case has been advertised for the required period of time, and property owners within 600 feet have been notified and notarized affidavits verifying the sign postings and letter mailings are on file.
Thank you. Eliza, you want to take this one, or who had?
It's me here, Eliza Monroe, representing the planning department. Planning staff requests that the staff report and all materials submitted here at the public hearing to be made part of the public record with any necessary corrections as noted.
So noted. Thank you.
Thank you. Case B20000003 is a request for a variance from the required street and side yard setbacks in order to construct an addition onto a single family dwelling, an existing single family dwelling. The applicants and property owners are Kelly and Camille Drews. The subject site is located at 105 Fairtosh Place. The case site area is highlighted in red. The site is in the suburban tier, zoned residential rural, otherwise known as RR, located within the Eno River Protected Area Watershed Protection Overlay District and within the county's jurisdiction. The site area is currently a single family dwelling. Per UDO section 6.2.1A.1, a 50-foot street and a minimum 12-foot side yard setback are required for a single family dwelling in the RR zoning district. The case area is a corner lot and thus has 2 street yards, one on Farintosh Place and one on Falkirk Drive. The applicant is requesting a 12-foot variance from the street yard setback along the west side of the parcel in order to bring the existing structure into compliance with the current ordinance. The survey, which was attachment 4 within the packet and is on the screen here, illustrates that the existing dwelling is 38.6 feet from the property line, encroaching into that required street yard. The applicant is also requesting a variance from the required side yard setback and for the addition of a garage, which is shown on attachment 1. As proposed, the addition would encroach into the required side yard setback and requires a variance from the Board of Adjustments for approval. UDO section 3.14.8 establishes the 4 findings that the applicant must make in order for the board to grant a variance. These findings requiring approval are identified in the staff report, and the applicant's responses to these findings are identified in the application. Both were within the packet that you all received. Staff will be available for any questions as needed during the hearing process, and I will also be able to flip through the different documents here, which you should have gotten a copy of, but I'll also have here for the view. And I do believe someone does have their hand raised.
Mr. Meadows?
Thank you. Eliza, would you show item 2 on the screen just for a moment, please?
This is the one that you're referring to, right?
That would be the one. Thank you. I just wanted to make sure that that was on the screen for a period of time. Thank you.
Good thing. And if there are no further questions for staff, I will allow Mr. Drews, or Mr. and Mrs. Drews, I'm not sure, to speak.
Is there any question? Are there any questions for staff before we continue? All right, with the applicant.
Hi, I'm Kelly Drews. I'm one of the property owners along with my wife, and I'll be representing the 2 of us for today's meeting. As Liza mentioned, essentially we're asking for 2 variances. One,
Mr. Drews, for one moment, I appreciate you coming. I got to administer the oath and ask you a question. Do you solemnly swear or affirm that your testimony and evidence shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. And do you consent to using this remote platform?
I do.
Thank you. Please continue.
Sorry. So essentially we're asking for 2 variances, one of which is to bring our current structure into conformity. It was built in 1977 before any of these guidelines were established. And as such, we'd like to just make sure it's in conformity with the current guidelines. And then we'd like to request a variance from the setback requirements in order to build an attached garage. We're hoping to build a garage that's roughly 24 feet wide and would therefore be between 4 feet and roughly 1 feet from the property line, depending on where on the garage you're measuring.
And Mr. Drews, do you would you like all of your written and oral testimony to be part of the record?
Yep, that's
fine. Any questions for the applicant?
Meadows has his hand raised. Chair Rogers.
Mr. Meadows.
Thank you, sir. Mr. Drews, thank you. I had a question for you about the roof of the proposed structure. If I read the site plans correctly, it looked like the wall of the structure was going to be about a foot or so from the lot line. Will the garage have an overhang, or have you thought about whether or not the roof portion of the structure might be even closer to the lot line than what's shown in the materials that we've been given?
That's a good question. So essentially, the overhang of the garage roof is still in, we can decide one way or another if we want or not. It'll essentially, the roof would be a 12-inch overhang if so, which would still be within the property lines because we had 1.3 feet to work with. So you'd still have within the lines if we had an overhang. We weren't aware that the overhang would be an issue in the sense of the lines themselves as it was in the air. If it is, then we might just say, okay, we'll deal with that and overhang on those sides and only include them on the front and back side if necessary.
Good question. Actually, one I had, I was going to wait. Any other questions for the applicant?
Lacey?
Mr. Lacey.
Mr. Drews, have you been in communication about this project with your next door neighbor whose land you abut on the garage side?
Yeah, we have actually. So that was the first person we talked to. We didn't want to create any bad blood. And they offered, in fact, to come and speak here, but we were told that they couldn't unless their testimony would just be the sake of their opinion. It wouldn't make any sort of difference on the the decision. So we have talked to them. They are for the garage. I think it would add value both to the property and the neighborhood as a whole. But again, since they were an appraiser, they couldn't state that. But yes, we have talked to them and they are okay with it.
Thank you.
Any other questions? Mr. Drews, where your current, where your proposed garage is there anything in that space currently?
Yeah, so we have a concrete driveway in the space. It covers, I would say, probably 60% of the proposed area. If you look at, I don't know if you can see item 1, Eliza. Yeah, so if you look down at the bottom there, there's the existing concrete driveway, and you can see it sort of gets wider as it enters towards the proposed garage. So there are some sections where the driveway is not currently there, but I would say at least 60% of it is taken up already by a concrete driveway, impervious surface already existing. But other than that, it's the only sort of open area in our property.
Okay, thank you. Any other questions?
Retchless.
Mr. Retchless.
Mr. Drews, that's a huge footprint of a garage. Are you going to use it for anything else? I notice you have windows and a second story.
Yeah. So essentially, when we were discussing with the planning department on how to go about this permit, we were told it's always better to ask for what you think could happen. And if you decide to go smaller, that's easier than asking for smaller than wanting more later. So what we were initially thinking was a 2-story garage, but I believe we're going to settle actually on a 1-story. It's only going to be used for a garage and a workshop space. We like to do a lot of renovations and such, and so we need a place for our tools, but nothing else beyond that. No business purposes or anything like that.
So am I to understand you said a single story or?
Yeah, so essentially when we applied for this, obviously with coronavirus, it was many months ago. And so we hadn't settled yet on the 1 versus 2-story. You're still getting quotes and so on. We think we're going to end up doing a 1-story just for financial reasons, and it would probably just make things a lot easier all the way around. But at that point, we'd already submitted the paperwork and it had been settled. So the plans still have a picture of a 2-story garage, but we're thinking it'll end up being only a 1-story, and it would end up having just unfinished space of, we'd use about half of it for the garage car storage and then half of it for tools and things like that.
Thank you.
Any other questions for Mr. Drews? All righty. Well, this is a variance. Let's close the public hearing just in case. We'll ask, is there anyone on the call who is against and in opposition of this request? Hearing and seeing none. All right, any discussion for board members? Thoughts?
This is Chad.
Yeah, I have a question, if I may.
Please, sir. Go ahead.
It seems like from the pictures that there's a garage on the left side of the house from the street. Is that staying in place with the new proposed garage?
We don't have a garage on the left side of the house.
Okay.
Sorry, it might be something weird with the pictures, but there shouldn't be anything on the left side of the house. It slopes down toward the street.
Okay, I guess I'm confused.
There's a little box that's the chimney, essentially. But that might be what you're saying. I don't know.
Okay.
Chad, did you have something?
As a matter of discussion, I really am very concerned about a structure that could be 14 plus feet in height, a foot or less from the lot line. I'm just not, I feel like there was a way to, I wish that there had been a different configuration that brought the building a little bit closer, farther from the lot line than it is. And that's, I just wanted to share my perspective on it. That's all. Thank you.
Lacey? Yeah, I have the same concern. The current neighbor would be fine, might be fine with it, but when the house goes for sale, having a building that close to the lot line makes me uncomfortable.
Understood.
Eliza Monroe, Planning Department here. I know this is usually the time for deliberation, but I thought I can provide a little bit more context if that is okay with the chair.
Please do.
From the understandings that we had the meetings with the applicant, the reasoning behind the garage being there is because of the existing concrete driveway. In addition, there's also the well towards the back of the lot and some substantially large trees, which you can kind of see here in the aerial. So based upon that, the location was decided upon there. Staff would like to note that in the midst of all the other things that were happening, we were not aware that there was a slight change in the design. So we would like to note that the design factor was not, there has been that change that was mentioned by the applicant, Mr. Drews, but the variance request is still for the setbacks. So I don't know if the height or the setbacks is the concern. I just wanted to chime in and provide that additional context for the location, as well as why you have the certain things here today.
Eliza, I'm glad you brought that up. I was looking at, can you pan back to yes, that image. And I was looking at this earlier that, one, you've got that septic in the front and then the well in the back. You really can't position it. It doesn't appear you can position it much differently.
And just to provide more color on everyone's comments, that's essentially what we were, when we had these initial design meetings with the planning department, we were saying, okay, here's our property, here's where the open space is, and here's why we think we should put it, here as opposed to somewhere else. The well requirements mean that we couldn't put it too much farther back. The ordinance that I found was a 25 foot from the well. The septic being in front sort of locks it in there. And unfortunately, the topography of our land means we can't really put it on the other side. It would be even closer to the street. As for the design change, again, I apologize for the potential change here. Obviously, the circumstances with the coronavirus makes things a little weird, but we are planning on having it a smaller structure overall due to it being one story. I couldn't bring it up in the time frame we had, but that is the goal. And our thinking behind it was that essentially the variance is for a setback from the property line. The overall width and length would still be the same regardless of the height. And so the overall variance would undoubtedly still require the same hearing, which is why we didn't rush to change anything before the hearing.
Yeah, I'm not really concerned about the height because the footprint would still be the same. And sounds like. Do you have something, Eliza?
There is a hand raised. The first hand that I saw was Brian Wardell, and after that is
Mr. Wardell. How are you?
I'm doing fine. Just wanted to remind the board about the review factors, and I'm not sure if we really dealt with the cause of the hardship itself, and whether or not there is a sufficient alternative, a smaller footprint, something that would impede less on the property line that actually could have been done or proposed. So I just want to, just remind the board of those review factors. I really haven't heard much about, what actually precipitated the hardship itself.
And then someone else who was the other person, had a comment?
Weimar had her hand raised as well.
Tisha, Ms. Wymore.
Just really quick, I actually have a question for the applicant, really, and I'm sorry that we're already past that point, but it just occurred to me. On this proposed garage, the wall facing the neighbor, would there be windows on that side of that structure?
We weren't anticipating putting any windows on that side, just sort of leaving it as a privacy for the neighbor. If that requires a change, then we can obviously look at the design and put in windows, but that was not the plan. As for the hardship comments, I don't know if I'm supposed to be addressing all comments that are being made at the moment, but essentially we were saying that to the topography of the land, placing it on the left side both puts it closer to the street yard and makes it harder due to the slope. And then due to the well and septic, it makes it difficult to move it forward or backwards in any direction. And then the fact that there's already a concrete driveway over the vast majority of the space means that it made sense to sort of put a structure over that.
Does anyone, any other thoughts?
DeLacy?
Mr. Lacy?
I was wondering if the applicant had considered moving the garage closer to the septic, or is there a distance that has to be maintained between the septic and any construction?
So we had considered it. According to the code 15A NCAC 18A.1950, the garage must be 5 feet from any foundation. So there is a limit there. We have 12 feet, I believe, to work with. But the other issue is that we didn't want the garage to we wanted the garage to remain subordinate to the primary structure. And if you can see, bringing it closer to the septic would bring it in front of the line of the house currently, which we felt would sort of make it the more of a primary structure, with the current house being like an add-on to it. And that was the idea. We wanted a line across the front.
DeLacy, so I see you didn't want to say, here's a garage and there's a house attached to it?
Right, exactly. We wanted to have a house with attached garage, not garage, you go first, and then there's a house if you want it.
Thank you.
Very good question. You know, one of the things I'm thinking about, and you know, if this really affected anybody, it's that adjacent property owner, and sounds like notice has been given to them, and the applicant has also talked to them. While they're not here to show their support, I guess they're, you know, it sounds like they're very well aware of what this would look like. So my concerns about that lot line are a little are eased because of that. Whether you know we can't determine, you know, they could sell their house tomorrow, or it could be 30 or 40 years from now, and that really has no impact in my mind on our decision, I don't think, but because we have to go with what, you know, current. They aren't here, but and so that's just what I'm thinking about that. Any thoughts from anyone else? All right. Does anyone want to make a motion? Does anybody want to talk about concerns further? Mr. Retchless.
You know, with this proposed footprint, I just think it should be brought back to the drawing board. It seems just be huge, and if he's already bringing down the height of it, I don't see why he couldn't make it smaller. But that's not for me to decide. So that's just my thoughts on this.
Anyone else?
I am also concerned with the size of the structure, not necessarily its placement, rather its length. It's 40 feet deep. The corner that is closest to the lot line, the one that gives me the most pause. I wonder if a less deep structure might be easier to accommodate. It might still need a variance, but perhaps the variance would be less than the variance necessary for this structure. Alternatively, and it's not my job to design this site, but I wonder if there's some way that it might move closer to the existing house, again, as a means of attempting to minimize that side yard setback variance that's necessary. And by the way, I do appreciate them coming in and trying to get the house quote unquote legal with respect to the street setback. I do appreciate that, but I don't feel as though this proposal minimizes the variance request in ways that could potentially be done, and would love to see a a modified design to address some of those concerns.
May I say something?
I'm not sure who said that.
Ian.
Oh, Mr. Kip, please do.
Yes. Okay. So I'm not crazy about the design or the fact that it's just a couple of feet from the side yard, but the neighboring house is quite a ways away. And that would really be the only person bothered. And the applicant said that they're not bothered by it. So sure, the house may trade later, but the future occupant neighbor doesn't have to buy the house if they can't stand the fact that the garage is effectively on their lot line. So I know this is in the RR zoning, it's suburban tier, but as an urbanist, I don't really have a problem with it. So that's just my opinion.
I have a question. Am I allowed to provide additional color at this point, or are we beyond that stage?
Go ahead.
Sorry. So there's been a lot of discussion about the neighbor and their thoughts on it, and I'm here to testify that we get questions daily about when we're going to start construction, because they're very interested in seeing it go up, in the sense that they have no problem with it. It is a good point that the neighboring house is quite a distance away. We actually have a row of trees and sort of bushes in between them existing that wouldn't be disturbed by this garage. And we also have a fence in the backyard that wouldn't be disturbed by the garage. So when we were designing this, we had just moved to the neighborhood, and so we didn't want to upset all of our neighbors. But as was mentioned, there's no one else that would be affected. And the reason for the design itself, in terms of the width of it, is that we were going for a 2-car garage. Standard 2-car garage is anywhere from 22 to 24 feet, and everything that we read about designing garages says that if you can get the 24 feet, definitely go for it. So you don't need your car doors opening them up on the sides if you have stuff there. So that was the reason for the 24-foot width of the garage. Just to get some color as to the reasoning behind our decisions.
Thank you. I gotta share the same sentiment as Ian. He actually put it more eloquently than I did. There is no opposition to this case. And the people who impacted the most are obviously the property owner and the adjacent property owner. So I've got to agree with you, Ian. I think Mr. Lacey, did you have something?
Brian Wardell did have his hand raised as well. Staff just wanted to chime in real quick to note that he did have his hand raised.
All right, Mr. Lacey and then Brian.
You're going to have a heck of a big shop, aren't you, in there? Because my garage is about 26 by 26, and I have room for both our cars and a workbench. But it seems like you're going to be super craftsman guy with the length. That's my problem was the length of it, and then you explained that you wanted a workshop. I just have workshop ending right now.
Yeah. So that's a good point, and that's entirely true. That's one of the biggest draws for us. Is it's less. It wasn't originally. Excuse me. The impetus was less to have a garage for cars and more to have a workshop in general. So my wife and I are very crafty or hands-on people. We have flipped houses before, and we wanted a place for all of our tools. Currently, we're using a bedroom that's sort of stuffed to the brim with tools and things like that. So that was the reason for the length, is to say, okay, we know we're going to want a shop, and we know that the shop we have has to be big enough to do all the things we want to do. Okay, in that case, let's see what we can do with the well setbacks and so on. So that was the reason for the length. It's just to have a shop that is big enough for everything we want to do.
Mr. Wardell?
Yes, just wanted to remind the board that any representation as to how the neighbors feel, or whether or not the neighbors are concerned about it, is really not anything you can consider or have use of as evidence, because the burden of proof is on the applicant to present substantial and competent evidence that they've met all the review criteria. And if they've done that, that's fine. I think that there are some outstanding questions about whether or not there is a substantial hardship that was created by the topography of the land, and whether or not they were present when they actually bought the property. And so, the UDO is, it's there as sort of an objective standard to protect everyone. So it doesn't matter whether or not the neighbors are concerned about it or not, their protection is the UDO. So it's the board's responsibility to just look at the evidence that's been presented and see whether or not, in fact, for a variance, this is not a use permit, this is a variance. And it requires a, sort of a supermajority for approval. So, you've got to look at it, and you got to look at the review factors and whether or not there are other alternatives that can be done to fit this design into the property if there's some alterations that can be made.
Very
I just
good.
want to remind the board about that.
Very good points. And I wasn't taking the applicant's testimony as for someone else into. I was actually thinking of their absence, even in the way of knowing that this hearing is happening. To think of assuming that they are must be okay with it. Mr. Drews, I don't know if you have your votes. And the second thing, you're welcome to, if you want to continue this, and then we can hear this again later, and you can maybe bring your neighbor or whoever some more evidence to the board. I don't think you have your votes today. We can call it, but we can.
I do have a question. When we were going through the planning process, I was told that if the votes didn't go my way, that we would have some sort of guidelines to come back and say, hey, if it matched these requirements, we would get the votes. And so that was sort of what we were. Is that still the case, where if the votes didn't come, you'd say, okay, if it fit these requirements, then it would, or that's sort of.
Planning Department, Eliza Monroe here. That, Kelly, Mr. Drews, is still the case. If the votes don't go your way, you can come back and resubmit. It is a new application, new case. So it would be a new application fee, new application with new documents and attachments. What the chairs were asking or suggesting is possibly continuing the case in order to information. I will say that with the other one coming back through, there is no assurance of approval with that one as well. It'll be, once again, you have your burden of proof to ensure that the findings in X, Y, and Z, the 4 findings and review factors have been met.
Yeah, I'm leaning on continuing if that is okay with, and that would be, I guess, by a vote of the board, Mr. Drews. And I don't want to ask, what are your thoughts on continuance?
So, if we have to, I would prefer obviously to continue than to reapply with a brand new fee and so on. And I understand that I can't testify on behalf of the neighbor. In terms of meeting the requirements, as far as I understood it, there was a requirement of unnecessary hardship from strict application. Part of the issue is that, as I mentioned, there's nowhere else really on the property that this could go due to either having a well there, a septic there, very large trees that would cause danger if we had to fell them for either ourselves or the neighbors. As for the hardship being there before we, it wasn't our doing. Well, the property was built in 1977, and we haven't changed anything since we've moved in September of 2019. So the conditions haven't changed. As for the size of the garage, possibly the design changing a bit, that may be possible. However, regardless of the design that ultimately happens, we would need to have a variance because of the distance.
Yeah.
So
I understand, and maybe what would help is some pictures that you take of this property and where, I'm trying to think of, I didn't see this.
So these are pictures of the surrounding area to show that it was supposed to be in harmony. When we originally were planning on doing this, it was going to be a minor special use permit, and then over the course of the application we had already submitted, and then we were told we should switch it to a variance and so on. So originally we were trying to show that it was in harmony with the neighborhood, being sort of garages next to the houses, some of which have breezeway attached like we were planning. So we
Well,
property pictures of it right now. I could pull one up, I suppose. I can find one, but
Well, you know, what I was thinking is, you know, pictures of your property and how the topography, I think that would be something to help. You know, is there a motion to continue the case, or does anybody else have any thoughts? Any board members?
DeLacy, if the applicant approves, with the applicant's consent, I move to continue this case until such time as the applicant comes back with something that would be more in keeping with the UDO.
Yeah, or more evidence. And I would
more evidence, yes.
Ask, you know, can this be, Liza or Jessica, is this something that could be put on next week's agenda?
Brian Wardell is raising his hand, so I'm going to let him kind of chime in with the language of that motion that was introduced, because I do think that was a motion introduced. So, Brian.
Right. So any motion to continue would have to be to a date certain, since the hearing has already been opened. The date certain could be the 30th. However, I would personally feel more comfortable with at least 30 days because of notice requirements, so forth and so on, and getting it back on the agenda. So I would say that it would be more appropriate to set it for the next 30-day hearing. So that, you know, my advice would be, if you are going to continue it to whatever the next scheduled 30-day agenda would be.
Staff, Liza Monroe, Planning Department. The next meeting would be July 21st. That one, if staff has any, would like to provide any context, that one has
I think it's the 28th.
Or, yeah, excuse me, the 28th. That one has not yet been advertised. The meeting after that, to give more context, would be the fourth Tuesday in August, which is August the 25th.
Mr. Drews, thoughts on continuance?
I mean, it sounds like it's probably the best option for us moving forward, rather than forcing a vote today. So I'm in favor of the continuance. So as far as to make sure I understand, for the continuing, we should come back with more pictures and sort of more evidence that backs up the claims of the hardship, as well as possibly having the neighbor themselves testify. We do have a question on that. So our neighbor is a bit elderly and may not have Zoom capabilities or the ability to easily understand how to perform Zoom. Would some sort of written document work, or do they have to be sort of in person?
Yeah, it has to be.
Okay.
It has to be in person.
Okay.
And I personally, I think that would be helpful, just to see that.
Okay.
Chair Rogers, Mr. Wardell has his hand raised.
I can't. Yeah, sorry, Mr. Wardell, please.
Right. So since that meeting may be virtual, I think there's an option to phone in, I believe, for a virtual meeting, as long as they take the oath. I think that is an option. If it's a live meeting, then of course they would have to show up and be present. And I don't think it's clear whether or not it's going to be virtual or it's going to be live. So just wanted to point that out. And just a recommendation for Mr. Drews, I would probably think about options for maybe some alternate designs as well, but I think staff can probably help you with that more than anyone else.
Okay. All right. Well, we've got a motion to continue this case until July 28th. Is that right, Mr. Lacey? You're on mute. You're still muted. You're muted.
Okay, sorry. I withdraw my earlier motion and request that I move that we continue this case to the date certain of August 25th in order to give the applicant sufficient time to make modifications. I know a week is short, a month might be pushing it.
If it-
I-
Sorry.
Go ahead.
I was just saying, if it's just on our benefit to have the August date, we would actually prefer July. I mean, I feel like we could turn it around in time. If it's just a question of better scheduling or the reason it has to be August for whatever reason on the council's end, then we understand. But if the only question of pushing it back until August would just be for our benefit, we prefer July actually.
Okay. Then I'm withdrawing the second motion. I move that we continue this case to the date certain of July 28th. Is there a second? I hope.
Yes, is there a second?
Rachel, second.
All right, Madam Clerk, will you call the board?
Ms. Burnham,
Yes.
Mr. Lacy,
Yes.
Mr. Kipp,
Yes.
Mr. Meadows,
Yes.
Mr. Rogers,
Yes.
Mr. Retchless,
Yes.
Ms. Wymore.
Yes.
Motion carries 7-0.
All right, Mr. Drews, we will continue your case and we'll rehear it, or we'll again on July 28th. Appreciate your time this morning.
Thank you.
Madam Clerk, will you call the next case?
B2-0000005, a request for a variance from the 10-foot no-build setback requirement for the construction of an additional onto an existing single-family dwelling. The subject site is located at 21 Copper Hill Court, is zoned planned development residential, is in the Falls of the Neuse Jordan Lake protected area in the suburban tier. The case has been advertised for the required period of time, and the property owners within 600 feet have been notified. Notarized affidavits verifying the sign postings and the letter mailings are on file.
Chair Rogers, I move to take a break for 10 minutes before we start this case, please.
All right, well, let's reconvene. It's 10:08 at 10:18. Is everybody okay with that?
Thank you.
Do we need a second for that motion?
No, I think the chair, it's at chair's
It's
discretion.
okay. Thank you.
We'll get started again in about 1 minute. All right, I think everybody is back with us. Eliza, would you like to take it over?
Did you want to, for the applicant, Megan and Jason, all of us do the oath?
Sure. Yeah, I was going to do that after your presentation, but yeah, we can do that. I'm looking at trying to go through the screen here. So the applicants are
Megan Dunphy Daly on the second screen, my second screen, and Jason Somarelli. Who I think is the architect.
So if you'll raise your right hand, and do you solemnly swear or affirm that your testimony and evidence shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you. And do you consent to using this remote platform?
I do.
I do.
All righty, thank you.
Okay, thanks so much. Eliza Monroe representing the Planning Department. Planning staff requests that the staff report and all materials submitted here at the public hearing be made part of the public record with any necessary corrections as noted.
So noted.
Thank you so much. Case B20000005 is a request for a variance from the 10-foot no-build setback requirement for the construction of an addition onto an existing single-family dwelling. The applicants and property owners are Megan Dunphy Daly and Jason Somarelli. The subject site is located at 21 Copper Hill Court. The case area is highlighted red on the screen. The site is in the suburban tier, zoned planned development residential or PDR, located within the Falls of Neuse Jordan Lake Protected Area Watershed Protection Overlay District, and is within the city's jurisdiction. On the site is currently an existing single-family dwelling. The applicant requests a variance from Unified Development Ordinance Section 8.5.9C, which requires that buildings and other features that require grading construction shall be set back at least 10 feet from the edge of a riparian buffer, henceforth referred to as the no-build setback. To the rear of the lot is an intermittent stream, as shown on the screen here, which requires a 50-foot buffer on either side of the bank per Unified UDO Section 8.5.4B1. An additional 10 feet no build setback is also required for the stream buffers per UDO Section 8.5.9C. The plan provided by the applicant showing the existing single-family home and the proposed addition indicates that the addition will encroach completely within the 10-foot no build. Lastly, the subject site is located within the Falls of Neuse Jordan Lake Protected Area Watershed Protection Overlay District and is subject to impervious surface limitations. The request does not exceed the impervious surface limits since the property receives a credit for impervious surface constructed prior to 1994. And the request for the addition is less than 24% of the maximum impervious surface total allowed for the parcel per UDO Section 8.7.2B. UDO Section 3.14.8 establishes 4 findings that the applicant must make in order for the board to grant a variance. These findings requiring approval are identified in the staff report, and the applicant's responses to the findings are identified in the application. Both are within your packet. Staff will be available for any questions throughout the hearing process. I would like to start by Megan brought to my attention this morning that there might have been some issues with the compressing of the file. So I don't know if everyone was able to see the red box that noted where the addition will be located. I'm not sure if everyone can see where my mouse is moving on the screen. I see some heads nodding yes. The addition would stop directly at this line here, which is in line with the 10-foot no-build setback, which is set back 10 feet from the 50-foot riparian buffer. And I'm open for any questions.
Any questions for Eliza?
This is Chad. Thank you, Eliza, for clarifying. That was going to be my first question, was I couldn't tell where on the site the addition was proposed. Will the imaginary red box that you drew on the screen, does that go for the entire rear elevation or only a portion of the rear elevation?
It will go for the entire rear elevation. I'm going to quickly go to the rear elevation, which is one of the very last portions of the PDF. Don't want to give anyone a headache, so I apologize for going through this so quickly. I believe this is the proposed rear elevation, and this here is kind of the floor plan layout for it. So it will go all the way to the entire rear elevation will be across that 10-foot no build in the back side of the property.
Any other questions for Eliza?
I'm trying to monitor raised hands. So if I don't see your hand, oh, I think there is Ms. DeLacy. Yes.
Eliza, are you saying that it's going to go into the no build setback, but not the riparian setback?
That is correct. It will go just to the no build setback. If it was to go into the riparian with the state required 50-foot riparian buffer, the applicant would be required to provide mitigation. So in an effort to stay out of that buffer, they are within encroaching or proposing to encroach within the city mandated and required 10-foot no build setback, but stay completely out of the riparian buffer.
Okay, thank you very much. I was
Eliza,
mistaking the fence for the size of the building.
I heard someone else speak, so I apologize. I didn't see who that was.
I apologize. It was me, Jessica Dockery. Would you please use the annotation tools and show a box roughly where this addition will be on this drawing?
This I can do. I apologize in advance for any crooked lines. They are not to scale. Sorry, it's not looking good so far, everybody, but.
Eliza, it's Jessica again. You can use a box.
Oh, I am learning something new every day today. I'm gonna undo and delete that because it is not. Can I turn this box? Having a little bit of an issue turning the box once it is drawn. I was not good at Pictionary as a child, but this is the gist. It will not be in the riparian buffer. It will stop in line with the no build setback. It'll be addition to not coming onto the deck, but along the what's my left side, probably your right side, because my screen is mirrored on the screen onto that back side. I apologize once again for the not to scale drawing.
It gives us an idea. I've got a question. So we've got, I was thinking that there is state legislation that addressed this a few years ago. I didn't know that municipalities could add to the riparian buffer. So there's a 50-foot, and then you've got an extra 10 feet. Is that what we're saying?
Within Durham, that is correct. The UDO section 859C requires that additional 10-foot in addition to the 50-foot. So in some cases it can be 60, or if you have 100-foot, it could be 110 feet. We can talk about environmental protection here within Durham, the city and county.
Okay. All right. Any other questions for Eliza? All right. Would the applicants come forward?
There is a raised hand. So sorry, to cut you off, Chair Rogers. Jessica Dockery has her hand raised.
Hey, Jessica.
Chair Rogers, to clarify, it is not in addition to the buffer. There are some restrictions to what type of construction or grading can take place in that 10-foot but it is not as restrictive as the buffer itself that is state regulated.
Yeah. Okay. Thank you
You're welcome.
for that clarification. All right. Applicants.
Thank you. Good morning. My name is Megan Dunphy Daly, and I'm present with my husband, Jason Somarelli. As Eliza mentioned, we live at 21 Copper Hill Court within the city limits of Durham. We're a growing family. When we first moved here, we were a family of 3. Our oldest daughter now is 4.5, and our second child is 2, and I'm pregnant with our third due in August. We love our house and our neighborhood, but we're filling out our house quickly, thus the need for an addition. So we want to build a second floor bedroom and bathroom off to the rear of our existing home. As Eliza drew for us, the addition we propose is at the back of our house, and the need for the variance is due to the uniqueness of our property and the 10-foot no-build setback from the edge of the 50-foot state riparian buffer. The addition will be a minimal intrusion. It will cross into the 10-foot no build, but not into the 50-foot riparian buffer. As Eliza mentioned, the buffer exists to protect an intermittent stream at the very back of our property line. This is an intermittent stream with a very deep embankment over 10 feet. It has little or no water flow depending on the season. The stream does not flood, and it's not listed as being in the flood zone by FEMA. The hardship created is due to the topography and uniqueness of our lot, its size, and the location of the house on it in relation to the stream. So building on the front of the house would put us too close to the road, and there's a steep slope down toward the house, meaning that any addition would be below road level. To the east and the west, there's not enough room to build due to property line setbacks and the Copper Hill Court site plan requirements for distance in between vertical structures. We're both environmental scientists who are faculty at Duke, and we're very passionate and thoughtful about preserving the environment. We're trying to do something that works with the property that we already have at a minimal effect to the natural environment. The primary purpose of Section 8.5 Riparian Buffer Protection Standards is to maintain land adjacent to the surface waters in a vegetated state to maintain water quality and wildlife habitat and mitigate erosion. Due to the unique slope and shape of the lot, building the addition behind the existing footprint of the house will have the least effect on water flow and drainage. Additionally, we've already been planting native vegetation throughout the property, and we plan to continue this before, during, and after the construction to enhance the existing vegetation of the buffer and the property. Thank you for your consideration.
All right, thank you. Are there any questions for the applicants?
Retchus has his hand raised.
Mr. Retchless.
Yes, you're not planning putting a deck off the back of that like you already have off the house, are you?
No, we're not going to add any additional structure beyond that, what was shown on the rear elevation. And I just want to point out, as Eliza mentioned, so we will fully encroach the 10-foot no build on one part of it, but because the stream is angled, we won't fully encroach in the 10 feet on the west end of the addition.
Gotcha. Thank you.
Any other questions? Thoughts? All right.
Mr. Chairman, is there anyone speaking against it? Do we know?
Well, that's what I was just about to get. Thank you for saying that. Just to make sure, is anybody on the call who is opposing this application? Anybody on the call who wishes to speak in favor of this application other than the applicant? Can't really see, Bonnie.
Jessica Dockery has her hand raised.
Ms. Dockery.
Mr. Rogers, just to clarify, we have no registered opposition for any of these cases today.
Okay.
If you want to save a step.
Thank you. All righty. This is a variance. We're not getting a recommendation from staff. Does anybody want to make a motion, or are there any further thoughts or discussion?
Meadows, I'll make a motion.
Please do.
I hereby make a motion that application number Oh, boy. B2 0000005. An application for a request for a variance from the required 10-foot no-build setback on property located at 21 Copper Hill Court has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted, subject to the following conditions. The improvements shall be substantially consistent with the plans and all information submitted to the board as part of the application.
We have a motion. Is there a second?
Retchless second.
All right, we have a second by Mr. Retchless. Susan, would you call the board?
Mr. Kipp,
Yes.
Mr. Meadows,
Yes.
Ms. DeLacy,
Yes.
Mr. Retchless,
Yes.
Ms. Burnham,
Yes.
Mr. Rogers,
Yes.
Ms. Wymore.
Yes.
Motion carries 7-0.
By a vote of 7-0, your variance has been approved.
Thank
Thank
you.
you for coming before the Board of Adjustment this morning.
Thank you for your time.
Madam Clerk, would you call the next case?
Case B2 0000007. A request for a variance from the street yard setback requirement for the addition of a covered porch onto an existing legal, non-conforming, single-family dwelling. The site is located at 4915 Montvale Drive, is zoned residential rural and in the rural tier. And this case has been advertised for the required period of time. Property owners within 600 feet have been notified, and notarized affidavits verifying the sign postings and letter mailings are on file.
All right. Well, we can go ahead and administer the oath. Is the applicant with us? Do we have video?
Yes.
All right. And let's go ahead and we'll administer the oath. Do you solemnly swear or affirm that your testimony and evidence shall be the truth, the whole truth, and nothing but the truth?
I do.
And do you consent to using this remote platform for this meeting?
I do. And I,
Liza, would you like to take over?
Staff wants to interject really quickly. Can you all hear me?
Yes.
Yes, there is someone that did also signed up to speak here. So I will need Mr. Gully. I do believe you're in here. You'll also need to unmute yourself and do the same thing that Miss Mundy just did.
All right, Mr. Gully, do you solemnly swear or affirm that your testimony and evidence shall be the truth, the whole truth, and nothing but the truth?
Yes, Mr. Chairman, I do.
And do you also consent to using this remote platform for this meeting?
I do.
All righty then. Eliza, I'll turn it over to you.
Thank you so much. Eliza Monroe with the Planning Department. Once again, planning staff requests that the staff report and all materials submitted at the public hearing to be made part of the public record with any necessary corrections as noted.
So noted.
Thank you, Chair Rogers. So case B200007 is a request for a variance from the street yard setback requirement for the addition of a covered porch onto an existing legal non-conforming single-family dwelling. The applicant and property owner is Martha Mundy. The subject site is located at 4915 Montvale Drive. The case area is highlighted in red. The site is in the rural tier, zoned residential rural or RR, and within the county's jurisdiction. I will clarify that the reason there is a white piece along the side here is where we're no longer in Durham County, so the zoning district is not registered there. The site area is currently a single family dwelling. Per UDO section 6.2.1A.1, the required street yard setback for a single family detached house in the residential rural zoning district is 50 feet. The applicant is requesting a 15-foot variance from the required 50-foot street yard requirement in order to construct a front porch that will wrap around the front facade of the house. The existing single-family dwelling is considered a legal non-conforming structure as it is encroaching 6 feet into the required street yard. Also, the lot is less than half an acre in size, and the minimum lot size for the RR zoning district is 2 acres per UDO section 6.2.1A.1, which would deem this site then a legal non-conforming structure. It was in existence prior to the development of the Unified Development Ordinance. Per UDO section 614.4.1, no enlargements or reconstructions shall create new nonconformities or encroachments without the approval of a variance, hence why we're here today. And that's required in UDO section 3.14. UDO section 3.14 also establishes the 4 findings that the applicant must make in order for the board to grant a variance. These findings requiring approval are identified in the staff report, and the applicant's responses to the findings are identified in the application, both which are within your packets. Staff will be available for any questions as needed during the hearing process, and I will quickly scroll through a little bit. I have had this up so you all can kind of see the proposed covered porch area in relation to the existing structure. And there are also some other attachments, including some elevations to show what the porch would look like. The existing main floor with the new covered porch and utility room, as well as a photo of the current existing porch, as well as the distance from the street with that. So just wanted to quickly go through those, and they are available. We can go back to them as the board or the applicant or Mr. Gully requests.
Thank you, Eliza. Are there any questions for Eliza from the board? All righty. Any hands raised?
I didn't see any in my scan just then.
All right. Would the applicant come forward?
Yes. I started talking about this about a year ago, wanting to do a front porch across the front of the property. And as well at the same time to move my current laundry room, which would be in the addition on the side between the house and the garage, with the possibility of moving a full downstairs bathroom downstairs, just trying to do what I might be able to do to stay in the property as long as possible. I moved into the property in 1992 with my ex-husband and children. I was surprised. So when in our neighborhood, we have an architectural review committee. So once I had these plans drawn, submitted those and got approval, and then the contractor submitted the plan to the county, and of course we got the bad surprise. As Ms. Monroe mentioned, I'm not close to a 2-acre lot. If anything, I'm probably one of the lot sizes. It's one of the smaller ones in the neighborhood because I'm right off Curly Road. There's really no way to build out. I think that the covered front porch would not put me right on top of the street. I think there still would be plenty. That's a visual judgment. I don't have landscape architects to testify on my behalf. But I think that it's consistent with the neighborhood. All of the comments that I've heard from other neighbors have been positive. So it's my hope that I'll be able to sit on this lovely front porch and use my new mudroom soon. Thank you.
And we have Mr. Gully.
I believe Mr. Gully is either here as a proponent or an appellant. So I don't know if this would be that time if you want to.
Okay. Well, then we'll wait if you don't mind. And any questions for the applicant from board members? All right. Well, Mr. Gully.
Sorry, there's a hand raised. Ms. Wymore does have her hand raised. Sorry.
Yeah, sorry, I didn't do the official. Real quick, is the garage, the detached garage, is that in existence now, or?
Yes.
I wasn't clear. Okay, and that will not be connected to this mudroom? It's separate completely already?
It's separate right now. The garage is not, is not in the same orientation, it's canted a little bit. But there is a covered pathway, a covered walkway between the garage and the house as is currently exists. I think that there will still be a covered walkway from the door, exit from the garage to the house onto the porch. But that hasn't been drawn where you might be able to see it on that landscape plan where you can see the orientation of the garage.
Which one do you need me to pull up, Martha? Sorry.
The one that's the landscape architect drawing from a long, long time ago, because it shows, that's it. There you can see the garage. I'm sitting here moving my mouse like I have control. But yes, there's a walkway between the garage and the house that is covered and is attached. The walkway's attached.
Okay, thank you.
Any other questions for the applicant?
Mr. Retchless has his hand raised.
All right, Mike.
Hi, Ms. Mundy. On the porch part of this structure, is that going to be just like a raised deck with pylons and a mansard roof kind of over it? Is that what you're proposing? Like a wood deck?
I'm not sure what a mansard roof is.
That's what you got.
Oh, okay, thank you. Yes, a mansard roof, new vocabulary for me. The plan, what I had requested that it would be open, and the contractor said because of the height, because it's so close to the ground, my lot's pretty flat in the front, that it would be possible to do that. So more open, an open. Yes, with landscaping in front of it.
Gotcha. So that is like a wood deck is what we're talking about as far as your porch?
Yes, yes.
Any other questions for the applicant? All right, well, Mr. Gully, would you like to say a few words?
I'd be glad to, Mr. Chairman. Do you want to swear me in? Or
oh, I did.
You're good, Mr. Gully. We swear.
Good. All right. Thank you. Mr. Chairman, members of the board, it's good to be with you this morning, and I appreciate your all's time and attention to this and all the other cases that I've listened to this morning. I had the joy of serving on the board for a couple of years back last century, and it's good to be with you this morning. I have been a resident of the Montvale neighborhood since 1993, along with my wife and kids. And I've served as chairman of the architectural committee for pretty much that whole time. It's a committee required under our restrictive covenants. Montvale, you all may know all this, but it's a 28 home subdivision with a relatively active homeowners association. And so I'm going to share some information, not technical evidence for the board to treat technical, but still information maybe that would be helpful to the board. So I sent out an email a couple of weeks ago to everyone in the neighborhood. I left Martha off, but I sent it to everybody else. And I said, I'm planning to appear before the board and just share the fact that my wife and I support her. But if there's any objections or any questions or any concerns, would people please let me know, because I'd like to try and express that as well. I received no objections, no questions, no concerns. You all know how your inboxes are flooded these days. And so most people I didn't expect to respond at all, but 17 of the 28 families wrote me back to say things like, we support it 100%, we support it, it looks very good, it looks wonderful, totally support, so on. And I was surprised that folks would take the time to respond like that. I think that, and you all, I know, see this a lot, but we're feeling like the front porch will encourage interaction in the neighborhood, community building, or neighborhood building. As you all know, these days of pandemic, we're out walking neighborhood streets a lot more. And everybody that I've talked with and everybody that's responded seems to think it would be a great addition, especially valuable during a pandemic. So those are my comments, Mr. Chairman. I'd be happy to respond to any questions if there are any.
All right, well, thank you, Mr. Gully. All right, any discussion among the board?
Mr. Wardell has his hand raised.
Mr. Wardell.
Sorry. Just once again, wanted to remind the board that this is a variance request. and what the review factors are, and that you do need a majority, supermajority in order to approve the variance. I'm not sure that, well, I don't know if there was material competent evidence presented on all the review factors, but that's up to the board to decide. I'm not sure what the hardship is with the property itself that caused this problem. But I just want to remind the board what the review factors are and to apply the review factors. You know, it's not really relevant what the neighbors believe, what the neighbors think. It's just whether or not this is in compliance with the UDO and whether or not there's a substantial hardship to allow a variance to the UDO.
Could I say something? When I moved into the property, there were no regulations saying that would have prohibited this. And that was in 1992. I think the zoning was changed in the was 2005, 2006, that then specified the 50-foot setback. The 50-foot street setback, as my understanding, is a requirement for a 2-acre lot. My lot is not near 2 acres. So that if there's a hardship that it's that the rules got changed on me, that I'm not doing this because well, there's some personal reasons why I want to do this, but then I know that that's not part of the UDO either. But I would have been allowed to do this if the lots, if you know, maybe I'd already be 50 foot farther back if I did have a 2-acre lot, but I don't. It's not even half an acre. That's all. Sorry. Thank you.
It's helpful. Does anybody have any questions or anything to discuss for discussion among the board about this case?
I am scanning making sure no one's raising their hand, but if I miss you, please feel free to unmute and speak.
All right, well, this is a variance, so we are not getting a recommendation by staff. If you have any concerns about this case, I'd really like to know what they are. All right, well, is there a motion? Anyone? Am I on mute?
All right. Meadows, I hereby make a motion that application B 2000007, an application for a request for variance from the required street yard setback on property located at 4915 Montville Drive, has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted, subject to the following conditions. The improvements shall be substantially consistent with the plans and all information submitted to the board as part of the application.
We have a motion. Is there a second?
Lacey, second.
We have a second. Madam Clerk, will you call the board?
Ms. Wymore?
Yes.
Mr. Retchless?
Yes.
Mr. Rogers?
Yes.
Mr. Meadows?
Yes.
Mr. Kipp?
Yes.
Lacey?
Yes.
Ms. Burnham?
Yes.
Motion carries 7-0.
By a vote of 7-0, your variance has been approved. You'll get an order from the Planning Department shortly. We appreciate you coming before the Board of Adjustment this morning.
Thank you very much. Thank you.
All right, we've got one case left. Will Madam Clerk, would you like to call it?
Case B 2000009, a request for a minor special use permit to allow for an 8-foot tall fence in the street frontage of the subject properties, industrial light It's in the falls of the Neuse Jordan Lake Protected Area, Watershed Protection Overlay, and in the suburban tier. This case has been advertised for the required period of time, and property owners within 600 feet have been notified, notarized.
Do you consent to this remote meeting platform?
Yes.
Thank you. Liza, would you like to take it over?
It's actually me. I'm Mr. Rogers.
Ah, thank you.
You're welcome. Good morning. I'm Cole Reniger, representing the Planning Department. Planning staff requests that the staff report and all material submitted at the public hearing to be made part of the public record with any necessary corrections as noted.
So noted. Thank you.
Welcome. Whoops. Case B 200009 is a minor special use permit for an 8-foot tall zinc coated chain link fence in the 50-foot street frontage of both parcels along Junction Road. The site is located at 250 and 804 Junction Road and is zoned industrial light and in the suburban tier. The applicant is Lynn Mitchell, representing Horvath Associates. The case area is highlighted in red. The site is in the suburban tier, zoned industrial light, and is within the city of Durham's jurisdiction. The site area is currently being used as a self-storage facility, as you can see right here in this area. A fence greater than 4 feet in height located between the structure and the street, except as exempt by Unified Development Ordinance, Section 9.9.1B, requires approval through an MSUP by the Board of Adjustments pursuant to UDO Section 9.9.1, fences and walls height. This minor special use permit request is to allow the fence located in the street frontage of the lots to be taller than 4 feet. The applicant is requesting an 8-foot high chain link fence. UDO 3.9.8A and B establish 4 findings and 13 review factors that the applicant must meet in order to grant a use permit. These findings and review factors are identified in the staff report and the applicant's responses to findings and review factors are identified in the application, both within your packet. Staff will be available for questions as needed during the hearing process.
Thank you, Cole. Any questions for Cole?
Just to start off, Lynn, if you do need me to reference the site plan, let me know. I can pull that up for you.
This is Chad. I'm sorry. I'm having a very hard time figuring out where the fence is. I think this site already has a fence, but some or all of it is coming down. There's new fence coming in, and I had a very hard time figuring out what's being proposed. Can you help me, Cole?
I'm gonna let Lynn discuss that. I'll pull up the site plan so she can point it out. Here it is. Lynn, is there a certain page you'd like me to go to show this, or zoom in, or I think she has to be moved to panelist, or she's muted at the moment.
Thank you.
Sorry for that, trying to unmute. If you can pull up the first sheet of the site plan, 201, C201, and go.
Sorry. Oops. I have to move my panel real quick, sorry.
Site plan west.
I'm trying to, it's just.
I understand.
It's taking a while to load.
Before we get a little bit too much further, Lynn, Mrs. Mitchell, sorry, Eliza Monroe staff, we would need to swear you in before you start providing testimony.
She's already been sworn in, but I was going to ask her if all of her written and oral testimony, she would like it to be part of the record.
Yes, please.
Thank you.
Is this the correct sheet, Lynn? 201?
Actually, that's the landscape plan. I think it would show a little better on the site plan, which is further up.
This one.
101. 101. There you go.
Yeah, this is one.
Yes.
It's okay.
Okay. All right. So there is an existing fence that extends from the, I wish I could use a mouse, from the upper corner of the site down across the frontage. It turn. It's down. It follows the edge of that exactly and continues on across an existing driveway. It then turns and goes, if this were the existing conditions, it would terminate there and go back toward the back of the property. This site plan is expanding the self-storage into a vacant lot down on the bottom far left. So what we will be doing is removing a portion of the fence that currently crosses the middle driveway and the fence that goes back toward the back of the property. And we will connect, well, if you could point just to the right of the proposed driveway, the other right, just above it. Anyway, the fence will connect to the existing fence before it reaches the driveway. And will run perpendicular to that fence down to a new gate that is down a little past mid-building. Right. So effectively, we are moving the gate from not an ideal, there wasn't stacking for it. You have to wait for gate access. We're moving it further into the property and making public space, making it accessible to the public to reach the office there and parking.
I noticed that Mr. Meadows has his hand raised.
That was my question, was what you're trying to help me through right now, which is what exactly is being proposed. It's kind of difficult to see how the fence, the fence that is the subject of the variance, what's going on. And I understand you're trying to answer that. So thank you. That was why my hand was raised.
Certainly, I think perhaps to clarify the portion of the fence that's in question, the existing fence is an 8-foot zinc coated chain link fence. And we will be connecting with an 8-foot zinc coated fence and running it perpendicular to the right of way for, it's about 30 feet until we get back into our yard, into the site. But we are improving the traffic situation and access to the site while still providing some security for our client.
Any other questions for staff, for Cole? All righty. Lynn, I'm going to turn it over to you and you could tell us what's happening.
Thank you.
If you've got anything else. Yeah.
Thank you. As we've already said, my name is Lynn Mitchell. I'm with Horvath Associates at 16 Consultant Place in Durham. I'm a registered landscape architect in the state of North Carolina. My license number is 2031. Thank you to the staff for helping us, for your assistance in coordination and preparing our petition. And Cole, you did a great job of presenting our request. And I thank you for the clarifying questions. So I'd like to only highlight a few specific items. This project is located on Junction Road south of Cheek Road. The site plan and associated special use permit application are for the expansion of the existing self-storage center. The request in front of you today is for an 8-foot tall zinc coated chain link fence to be located in the 50-foot street frontage associated with the site plan. And as I said, that will be running perpendicular to the right of way.
If you visited the site prior to this meeting, you likely noticed, as we said, the existing 8-foot tall fence on the property running parallel to Junction Road. I realize we've said this previously, but I think it helps to explain it again. The proposed fence will be an extension of a portion of the existing fence and will be used for security, while the site design and placement of the proposed fence allows better access onto and from Junction Road. Our site plan is improving access to and from Junction Road by relocating the existing gate at the central driveway further into the site and to allow both pedestrian and vehicular traffic to enter the site without needing access through a gate as it exists today. The proposed gates will be siren activated to allow emergency vehicles immediate access to the facility in case of an emergency. Since the proposed fence will not be any closer to the right-of-way than the existing fence, and the majority of the parcels along the portion of Junction Road are industrial in nature, the expansion of the existing fence will not be injurious to the value of properties in the general vicinity. The proposed expansion of the fence will not adversely affect the health or safety of the public. The proposed fence height will have no impact on the site's lighting, utilities, open space, or environmental protection of stream buffers and tree coverage areas. The proposed site plan illustrates project boundary buffers to help screen the new construction from adjacent parcels. The 8-foot fence will have minimal impact on surrounding properties and is compatible with the surrounding industrial zone properties. And that is, in summary, I appreciate your time this morning, and I ask that you vote in favor of the expansion of this 8-foot tall chain link fence for security of the self-storage center while creating better vehicular and pedestrian flow in and out of the proposed development. I'm available for any questions.
Any questions for the applicant? I've got one. Cole, you're going to have to help me with the hand raises. I can't see them, but or whoever is monitoring those. How? And you may have said this, but I'm with Chad a little bit. I'm having a hard time kind of following it. But how much of the frontage, or how long? What is the how many feet is this fence are you looking at for the frontage, for the purpose of your variance?
That's a question for me, sir?
Yeah, I think so.
Lynn Mitchell with Horvath.
Probably did a terrible job asking it, but
sorry. I thought you might have been asking, Cole. Currently existing on the site on the frontage, there's 286 linear footage, including the 2 gates. 77 feet of that will be removed and then effectively pushed further into the site, right, and connected with a perpendicular. And actually we're moving it back 166 feet.
And which, and so it'll be 286 feet of 8-foot tall fence. Is that what you're?
That's what's existing now. We'll be taking 77 of that away and turning it perpendicular.
Right. Yes. Going inside.
Yes, sir.
And okay. All right. Any questions for the applicant? Any other ones?
Hi, Mike Rutschels here. Ms. Mitchell, is there any Constantine razor wire or anything like that going on this new fence?
No, sir.
Thank you.
Any other questions, thoughts? All right. Is there, well, I guess we can ask for the staff's recommendation.
Before that, we just would like to recognize, is Reggie Oakley, and I see he's there. Does he have anything to speak to for this case before we move on?
Did not see that.
Hi, this is Reggie Oakley. Are you able to hear me?
Yes.
Great. My name is Reggie Oakley. I'm a licensed commercial real estate broker. I work for real estate associates.
Sorry to
located
interject. I don't believe he's been sworn in. So you probably want to do that first.
All right, Mr. Oakley, do you solemnly swear or affirm? Hold on, do we have? I don't have a video of him. There we go. Mr. Oakley, do you solemnly swear or affirm that your testimony and evidence shall be the truth, the whole truth, and nothing but the truth?
I do.
And just one more thing, I think you have to, do you consent to this electronic platform?
Yeah.
All righty. You may continue. Now, did you have something, Mr. Oakley, to say?
So quickly, just introducing myself.
Got you pretty bad.
Reggie is
probably messing up.
Work in land and development. I work for real estate associates, 33.
Mr. Oakley.
Can you hear me now, sir?
Well, the first 10 seconds or so was
nothing to add, sir.
All right. Okay. All right. Any discussion, questions from board members?
DeLacy?
Mr. Lacey.
I believe Mr. Oakley said something about being a real estate appraiser. Did he have testimony on that?
It sounded like he was a real estate broker, he said, commercial real estate broker.
He's here in a support capacity with no prepared remarks, but is available for questions from the board.
Okay. All righty. Any other thoughts, questions from board members for the applicant? All right. Is there any discussion? All right, Cole, would you like to give a staff recommendation?
Yeah, staff recommends approval of case B200009. So as long as the permit shall be substantially consistent with the site plan D1900259 and all information submitted to the board as part of the application.
All right, well, I'm gonna ask one more time. Is there any discussion, any thoughts from board members before we ask for a motion? All right, is there a motion?
It's me, Chad.
Thank you.
I hereby make a motion that application number B20000009, an application for a minor special use permit on property located at 750 and 804 Junction Road, has successfully met the applicable requirements of the Unified Development Ordinance and is hereby granted subject to the following conditions. The improvements shall be substantially consistent with the site plan. Case D1900259, and all information submitted to the board as part of the application.
Thank you, Mr. Meadows. Is there a second?
Second. Oh, take it, Chris.
Chris has got the second.
Second. So Retchless had the second.
Ms. Burnham.
Burnham, thanks. Okay, roll call. Mr. Meadows?
Yes.
Ms. Burnham?
Yes.
Mr. Kipp?
Yes.
Ms. DeLacy?
Yes.
Mr. Rogers?
Yes.
Ms. Wymore?
Yes.
Mr. Retchless?
Yes.
Motion carries 7-0.
By a vote of 7-0, your minor special use permit has been approved. We wish you the best of luck and thank you for coming to the BOA.
Thank you very much.
All right. Well, that ends. I believe we don't have any more cases. Do we have any old business? All right. Any new business? All right. Our next scheduled meeting is a week from today, June 30th at 8:30, same time. We've got I think the agenda has already been sent out to everybody. Hopefully you've had a chance to look over that. It will be another virtual meeting.
Mr. Rogers, before you end the meeting, we do need to vote on orders.
Okay.
Jessica, I was just looking at the agenda. I don't actually see that on the agenda.
It's not.
So,
Lacey, I recommend I move that we add orders to the agenda. I know this is late, but it's better than never. Can we make that motion to amend the agenda to allow for the approval of orders?
Kristen.
I feel comfortable with that. Brian, what are your thoughts?
Well, I think it's a little bit problematic given the the way we typically approve orders. I don't know if we have draft orders in front of the board. But
We do, Mr. Wardell.
they do have the draft orders?
Everyone should have a copy of the draft orders.
Okay, well, if they have copies of the draft order, then I think it's fine. You just do it under new business, not a problem.
All right. Because she had this motion on, do we need to get a second?
You don't need a motion. You don't need a motion.
Okay. I don't think. All righty. Well, then we'll add those. I
withdraw that motion then.
All right. Well, I'm guessing we're going to go back to B190032 to approve that order. We need a motion and a second for each one of these and a vote.
From the individuals that voted upon it. Just
That's
wanted
right.
to chime in with.
All of these were voted 7-0 unanimously.
Correct. And Susan will have to call after the motion and second has been made.
Okay.
Meadows, move approval on the order for case, oh my goodness, B190032.
Is there a second?
Lacey.
Susan?
Roll call.
Yes.
Ms. Burnham,
Yes.
Mr. Davis.
He's not here.
I'm sorry. Ms. DeLacy,
Yes.
Mr. Kipp,
Yes.
Mr. Meadows,
Yes.
Mr. Rogers,
Yes.
Mr. Retchless,
Yes.
Ms. Wymore.
Yes.
Motion carries 7-0.
All right. We need a motion for B20000001. Is there a motion?
Lacey.
All right. Is there a second to approve that?
Retchless.
All right. Susan, go ahead.
Ms. Wymore,
Yes.
Mr. Retchless,
Yes.
Mr. Rogers,
Yes.
Mr. Meadows,
Yes.
Mr. Kipp,
Yes.
Ms. DeLacy,
Yes.
Ms. Burnham.
Yes.
Motion carries 7-0.
All right. Need a motion for B20000005.
Burnham.
Thank you. Is there a second?
Meadows.
Lacey. Oh,
Meadows has it. All right. Susan.
Mr. Kipp,
Yes.
Ms. DeLacy,
yes.
Mr. Meadows,
Yes.
Ms. Wymore,
Yes.
Ms. Burnham,
Yes.
Mr. Rogers,
Yes.
Mr. Retchless.
Yes.
Motion carries 7-0.
We're getting through this. Two more. B20000007. Is there a motion?
Burnham.
Burnham, who's our second?
Lacey. Oh,
One more it is. All
one
right.
more.
Susan.
Ms. Burnham,
Yes.
Ms. DeLacy,
Yes.
Mr. Kipp,
Yes.
Mr. Meadows,
Yes.
Mr. Rogers,
Yes.
Mr. Retchless,
Yes.
Ms. Wymore.
Yes.
right.
Motion carries 7-0.
One more, B 2000009.
DeLacy.
Bingo.
Yeah.
Who's got the second?
Burnham.
Burnham. All right, Susan.
Mr. Rogers,
Yes.
Mr. Retchless,
Yes.
Ms. Wymore,
Yes.
Mr. Meadows,
Yes.
Ms. DeLacy,
Yes.
Ms. Burnham.
Yes.
Motion carries 7-0.
And Eliza Monroe, Planning Department, we skipped one, B2000003. We.
3 was continued.
That got
Was
continued.
there anything that needs to be
Yeah.
done? Continue?
I think we missed 5.
We did do 5.
We did 5.
Okay. And 6 was withdrawn.
This is withdrawn. 3 since continued, we don't need to do anything. Yes, Krista. Cool beans. I'm gonna go.
But three, there was a motion to continue on 3, I believe, and then it was approved. So,
We've completed them.
Okay.
right.
Okay. All right. Well, we efficient. I feel pretty good about this. Is there a motion for adjournment?
Wait, I have something to say
Hold on,
before we adjourn. Great job, you guys. But what I wanted to say is that Brian and I have been working on exploring options for contested cases and having those in a remote or in-person setting. So you will probably receive an email from me this week kind of laying out the options and what we might be proposing for July, or just getting some feedback from you on your level of comfort with the possibility of an in-person meeting. Again, we are still sort of plotting it out. And so I can't assure you that's exactly what the question will be that's proposed to you, but wanted to sort of get that on your radar as something coming down the pike.
Thank you for doing that. And I really appreciate everybody being here today, and Micah and Jessica as well. So thank you for taking your time and joining us as well. And everyone else.
DeLacy, I've got just a housekeeping. Mr. Chairman, if you hadn't been able to see the hand raising, in order to see that, you have to click on the participants and you get yourself another box.
I was going to ask that question, Regina.
Yeah.
And where is that at?
Go down to the bottom of your screen. You'll see
gotcha.
mute stop video participants. Click on that and magically a sidebar will come up with people's names on them. And at the bottom of that is a place on the right-hand corner where you can click raise hand.
Yeah.
Fantastic.
Good job.
And so are we going to have...
Mike, you have something? Okay.
I had one more thing too, is on approval orders. Are we going to get that ahead of time so we're not sending it all to Chad?
What's that?
But he does so well.
I couldn't.
Share the love. Share the love.
This is Jessica. We had thought that we emailed them to you ahead of time, but apparently that email did not make it to all of you. So we sent them again before the meeting today. We'll make sure to send those even earlier. And if you don't see them before the meeting, let us know and we will send them again to individuals.
Cole sent me a few days ago. So, all right. All righty. That's anything else? Anyone else? All right. Thank you for your time. Does anybody have a motion for to adjourn?
Lacey. 2 bingos. I move to adjourn.
I'm thinking we need a second. All right. Thank you. We could do a voice vote for this, right? All in favor, say aye.
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 Thank you. All right. We'll see you guys next week at 8:30.
All right.
Thanks.
Bye, guys.
Bye.
Bye-bye.